If you have been watching YouTube videos or scrolling through social media recently, you have probably seen dramatic headlines about green cards and visas, and you might be feeling anxious or confused about what is actually happening with your immigration case. Let me tell you something right now. You are not alone in feeling this way, and the good news is that most of what you are hearing is either incomplete, exaggerated, or simply not true. My name is Sakib, and this is Global Immigration Updates, where we focus on facts, not fear. We do not create panic, we do not spread rumors. What we do here is break down official immigration news in simple language so that you can make informed decisions about your future in the United States. Today, we are going to talk about the big USCIS update for January 2026. We will discuss the latest visa bulletin, what it means for green card applicants, changes in processing times, and most importantly, who is actually affected by these updates and what you should realistically do next. This is going to be a detailed discussion, so stay with me until the end because I will address the most common questions and concerns that people have been asking. Let me start with what actually happened in January 2026. The U.S. Department of State released the visa bulletin for January, and USCIS confirmed that applicants can continue using what is called the dates for filing chart to submit their green card applications. Now, if you are not familiar with how the visa bulletin works, let me explain this in simple terms because this is one of the most misunderstood parts of the U.S. immigration system. Let me start with what actually happened in January 2026. The U.S. Department of State released the visa bulletin for January, and USCIS confirmed that applicants can continue using what is called the dates for filing chart to submit their green card applications. Now, if you are not familiar with how the visa bulletin works, let me explain this in simple terms, because this is one of the most misunderstood parts of the U.S. immigration system. The visa bulletin is published every month by the U.S. State Department. It tells you when you can file your application for a green card based on something called your priority date. Your priority date is usually the date when your employer or family member first filed a petition on your behalf with USCIS. Think of it like a queue number at a government office. The earlier your priority date, the closer you are to the front of the line. Now, the visa bulletin actually has two different charts. One is called the final action dates chart, and the other is called the dates for filing chart. The final action dates chart shows when your case can actually be approved. The dates for filing chart shows when you can submit your application even if approval is not immediately available. USCIS decides each month which chart applicants should use, and for January 2026, USCIS has confirmed that both family-based and employment-based applicants should use the dates for filing chart. This is good news because the dates for filing chart is usually more generous, meaning more people become eligible to file their applications. Let me talk about the specific updates for employment-based green cards, because this is where we saw the most significant movement in January 2026. For applicants in the EB1 category, which includes people with extraordinary ability, outstanding professors and researchers, and multinational executives and managers, most countries remain current. This means if you are from most countries and you are in the EB1 category, you can file your application right now regardless of your priority date. However, for applicants born in India and China, there are specific cutoff dates. For India, the EB1 category moved forward by about 11 months to February 1, 2023. For China, the category moved forward by about 8 days to February 1, 2023. Now, I know some people are looking at this and thinking that 8 days does not sound like much progress, but remember, any forward movement is progress, and it means more people can file their applications. For the EB2 category, which includes people with advanced degrees or exceptional ability, we also saw movement. For most countries, the dates moved forward by about 3 months. For China, the dates moved forward by 1 month, and for India, the situation is more challenging. India EB2 applicants are facing significant backlogs, and the movement has been much slower. The current date for India in the EB2 category is around January 2013 in the final action dates chart, which means there is approximately a 12 to 13-year wait for many applicants. For the EB3 category, which includes skilled workers, professionals, and other workers, the movement was more modest. Most countries saw slight forward movement, while India and China experienced minimal changes. One notable update is for Chinese applicants in the EB3 Other Workers category, which moved forward by 1 full year to October 1, 2019, in the dates for filing chart. Now, let me address family-based green card applications, because many people watching this video are waiting to bring family members to the United States. For family-based categories, the January 2026 bulletin showed mixed results. The biggest winner was Mexico, which saw significant forward movement across multiple categories. For example, the F1 category for unmarried adult children of U.S. citizens moved forward by 6 months for Mexico. The F2B category for unmarried adult children of permanent residents also moved forward by 6 months. For applicants from India, China, and the Philippines, most family-based categories remained unchanged or saw very minimal movement. The F2A category, which is for spouses and children of permanent residents, currently shows February 1, 2024 as the filing date for most countries, which is actually quite recent compared to other categories. Here is what I want you to understand about these updates. The visa bulletin movement is based on visa availability, which is controlled by annual limits set by Congress. Every year, there are only a certain number of green cards available for each category and each country. When demand exceeds supply, backlogs form, and priority dates move slowly or sometimes even go backward, which is called retrogression. The reason India and China often face longer wait times is because of something called per-country limits. By law, no single country can receive more than 7% of the total number of employment-based or family-based green cards available each year, regardless of demand. Since India and China have very high demand for U.S. green cards, applicants from these countries face much longer wait times, even if they would otherwise qualify. Now, let me address one of the biggest rumors I have been seeing on social media. Some people are claiming that USCIS has dramatically changed its policies, or that green card processing has become much faster overnight. This is not accurate. What has happened is that the visa bulletin has moved forward in certain categories, which allows more people to file their applications. This does not mean approvals are happening faster for everyone. It simply means more people are now eligible to submit their paperwork. In fact, USCIS processing times vary significantly depending on the type of application, the service center handling your case, and your individual circumstances. According to recent data, Form I-485 Adjustment of Status Applications, which is the main form for getting a green card inside the United States, are currently taking between 8 to 10 months for family-based cases and varying timelines for employment-based cases depending on visa bulletin movement and priority dates. Form N-400 naturalization applications are actually processing much faster than in previous years. The median processing time is now around 6 months, which is the fastest it has been since 2016. If you are eligible to apply for citizenship, this is actually a very good time to file because USCIS has made significant progress in reducing the naturalization backlog. Form I-130 petitions for family members are taking approximately 10 to 14 months for immediate relatives of U.S. citizens. These timelines can vary by location, so it is important to check the USCIS processing times page for the specific office handling your case. Let me be very clear about something that causes a lot of confusion. Just because your priority date is current in the visa bulletin does not mean your case will be approved immediately. There are several steps that must happen first. You need to file your application with all required documents. You need to complete biometrics, which is the process where USCIS collects your fingerprints and photographs. You need to complete a medical examination with a USCIS-approved civil surgeon. You may need to attend an interview, and USCIS needs to complete background checks and review your entire case. All of these steps take time, and this is where people often become frustrated because they see their priority date is current, they file their application, and then they wait months without any updates. This waiting period is normal. It does not mean your case is stuck or that something is wrong. It means USCIS is processing thousands of applications and they are working through them in order. Now, let me talk about premium processing because many people ask me whether they should pay extra to speed up their case. Premium processing is a service offered by USCIS for certain types of applications. It guarantees that USCIS will process your case within 15 business days for most forms or 30 to 45 business days for specific forms. The fee for premium processing is currently $2,805. However, premium processing is only available for certain forms. It is available for Form I-129, which is used for temporary work visas like H-1B, L-1, and others. It is also available for Form I-140, which is the immigrant petition for employment-based green cards. Premium processing is not available for Form I-485 adjustment of status applications, which is the final step to getting your green card. This means even if you use premium processing for your I-140 petition, you still need to wait for regular processing times for your I-485 application. Let me address another common question. What should you do if your priority date is current in January 2026? First, if your priority date falls before the cutoff date listed in the Dates for Filing chart for your category and country, you should prepare to file your application immediately. I say immediately because visa bulletin dates can move backward in future months, which is called retrogression. If your date is current now, do not wait hoping it will still be current next month. File as soon as you can. Second, gather all required documents. This includes birth certificates, marriage certificates, if applicable, police clearance certificates from every country where you have lived for more than 6 months since age 16, evidence of financial support, and any other documents specific to your case. Make sure everything is translated into English by a certified translator if the original documents are in another language. Third, schedule your medical examination with a USCIS-approved civil surgeon. The medical examination must be completed on Form I-693, and the civil surgeon will check for certain health conditions and ensure you have the required vaccinations. This form is valid for 2 years from the date it is signed by the civil surgeon, so you can complete it before filing your application if your priority date is close to becoming current. Fourth, file your application with USCIS at the correct address. Pay attention to where you need to send your application because sending it to the wrong location will cause delays. Include the correct filing fee, which varies depending on your category and whether you are including additional forms like I-765 for work authorization or I-131 for travel permission. After you file your application, you will receive a receipt notice from USCIS, usually within 2 to 4 weeks. This receipt notice will have a 13-character receipt number that you can use to check your case status online. Keep this receipt notice in a safe place because you will need it throughout the process. Now, what should you do if your case is taking longer than the normal processing time published on the USCIS website? First, check the USCIS processing times page to see the current estimates for your form type and the office handling your case. If your case is outside normal processing times, you can submit an inquiry through the USCIS online system or by calling the USCIS Contact Center at 1-800-375-5283. You can also request help from your congressional representative. Many congressional offices have staff dedicated to helping constituents with federal agencies like USCIS. A congressional inquiry does not guarantee faster processing, but it can help identify if there is a specific issue with your case that needs attention. Let me talk about something that many people are not discussing, which is the importance of maintaining your status while waiting for your green card. If you are in the United States on a temporary visa like H-1B, L-1, F-1, or any other non-immigrant status, you need to make sure your status remains valid while you wait for your green card application to be processed. If your status expires and you do not have a pending adjustment of status application, you could be subject to removal proceedings. This is why filing your I-485 application as soon as your priority date is current is so important. Once USCIS receives your I-485 application, you are generally protected from removal even if your underlying visa status expires, as long as you do not leave the United States without advance parole permission. You can also apply for work authorization using Form I-765 and travel permission using Form I-131 at the same time you file your I-485. Now, let me address some of the fears and concerns I have been seeing in the comments and messages. Many people are worried that immigration rules will change suddenly and affect their cases. I want to be very clear about this. Immigration laws in the United States do not change overnight. Any major changes to immigration law must go through Congress, which is a lengthy process. Even if there are proposals to change certain aspects of the immigration system, those proposals need to be debated, voted on, and signed into law before they take effect. Furthermore, most changes to immigration law include provisions that protect people who already have applications pending or who have already taken steps based on existing laws. This is called grandfathering, and it means that even if rules change, people who relied on the old rules in good faith are usually protected. This does not mean changes never happen, but it does mean you should not panic every time you see a headline about potential immigration reform. Another concern I see frequently is about visa bulletin retrogressions. Yes, priority dates can move backward in future months. This has happened before, especially in categories with high demand like India EB2 and EB3. However, if you have already filed your I-485 application when your priority date was current, your application remains pending, even if the dates move backward. USCIS will eventually process your case when your priority date becomes current again. Let me talk about what you should not do. Do not rely on information from unofficial sources, social media rumors, or YouTube channels that create panic and fear. Unfortunately, there are many content creators who exaggerate or misrepresent immigration news to get views and clicks. Always verify information by checking official government websites. The primary source for visa bulletin information is the U.S. State Department's travel.state.gov website, where the visa bulletin is published every month. For USCIS policy updates and processing times, check uscis.gov directly. For legislative updates, you can check congress.gov to see actual bills and their status. These are the official sources, and they provide accurate information without the drama and speculation. Do not pay for services or consultations from people who claim they can speed up your case through special connections or insider access. USCIS does not have a system where certain people can jump the line by paying extra money to unauthorized parties. The only way to expedite certain applications is through official premium processing, which I discussed earlier, or through formal expedite requests for emergencies, which USCIS evaluates on a case-by-case basis. Do not leave the United States without proper travel permission if you have a pending adjustment of status application. If you leave without advance parole, your application will be considered abandoned, and you will need to start the process over, this time through consular processing abroad. Always apply for advance parole using Form I-131 before making any international travel plans. Let me share some perspective on the bigger picture. The U.S. immigration system processes millions of applications every year. In fiscal year 2023, USCIS processed over 10 million cases and reduced its overall backlog by 15%. The agency has been working to improve efficiency and reduce processing times through technology upgrades, hiring additional staff, and implementing internal goals for processing different application types. Naturalization processing, as I mentioned earlier, has improved significantly. Form N-400 applications are now being processed in approximately 6 months, which is a major improvement from the 10 to 11 months they were taking just a few years ago. This shows that progress is possible when USCIS focuses resources on specific areas. USCIS has also been expanding premium processing to more application types. In 2023, USCIS began offering premium processing for certain Form I-539 applications for changes of status to F1, F2, M1, M2, J1, and J2 categories. This gives applicants more options for expedited processing when time is critical. Now, let me address who is actually affected by the January 2026 Visa Bulletin update. If you are an employment-based applicant from India or China with a priority date in 2022 or 2023 for EB1, or if you have a priority date in the early 2010s for EB2, the January Bulletin is relevant to you. Check the dates carefully to see if your priority date is now current. If you are a family-based applicant from Mexico and your priority date is in the mid-2000s to late 2000s, depending on your category, you may now be eligible to file. If you are from the Philippines and waiting in the F3 or F4 categories, there was some modest movement that may affect you. If you are from most other countries in employment-based categories like EB1, EB2, or EB3, and your priority date is recent, you may already be current or close to becoming current. The key is to check the specific chart for your category and country on the State Department's Visa Bulletin page. If you are someone who is not yet in the immigration process, meaning you do not have a petition filed on your behalf yet, the Visa Bulletin does not directly affect you at this moment. You first need to have a family member or employer file a petition for you, and once that petition is approved, you will receive a priority date. Then you will start watching the Visa Bulletin each month. Let me conclude with some practical advice. Stay informed by checking official sources regularly. The Visa Bulletin is published around the middle of each month, usually between the 8th and 15th. USCIS typically announces which chart to use, dates for filing, or final action dates within a few days after the bulletin is published. Set a reminder to check these sources monthly if you are actively waiting for your priority date to become current. Keep your documents organized and ready. If your priority date is getting close to the cutoff dates, start gathering your documents now so you are ready to file quickly when your date becomes current. This includes getting new police clearances if needed, scheduling your medical exam, and making sure your financial documentation is current. Maintain your immigration status. If you are in the United States on a temporary visa, make sure you extend your status on time. Do not let your visa expire while you're waiting for your green card. If you need to travel, make sure you have the proper authorization and valid visa stamps. Seek professional help when needed. Immigration law is complex, and individual circumstances vary widely. If you have specific questions about your case, especially if you have had previous visa denials, criminal history, or complex family situations, consider consulting with a licensed immigration attorney. An attorney can review your specific situation and provide personalized advice. Do not rely solely on general information from YouTube videos or internet forums. Be patient and realistic. The immigration process takes time, and while it can be frustrating to wait, most people who follow the rules, file their applications correctly, and maintain their status eventually receive their green cards. The system is not perfect, and there are certainly areas that need improvement, but it does work for millions of people every year. Finally, remember that immigration rules and policies exist within a legal framework that includes due process protections. Even if you hear alarming news or dramatic headlines, the legal system has checks and balances. Courts review USCIS decisions, Congress makes laws that must go through a democratic process, and people have rights to appeal adverse decisions. This does not happen overnight, and panic is rarely productive. The January 2026 Visa Bulletin brings forward movement for many categories, continued use of the dates for filing chart, and opportunities for thousands of applicants to move forward in their green card journey. Whether you are able to file this month or you are still waiting for your date to become current, staying informed and prepared is the best strategy. If you found this information helpful, please subscribe to Global Immigration Updates and turn on notifications so you never miss an update. Share this video with anyone you know who might be worried about their immigration case. Leave your questions in the comments below, and I will try to address them in future videos. Remember, we are here to provide facts, not fear, and to help you navigate the immigration process with confidence and clarity. Thank you for watching, and I will see you in the next update.